Hi, I'm Stuart Morris, the founding partner of Morris Law Group, and we're here to talk about a topic that many of our clients deal with, and that is the irrevocable trust and Crummey powers. Most people hear Crummey powers and they think they're just lousy powers in the trust, but that's not the case. Crummey powers are critical powers contained in the trust to make sure that contributions made to the trust qualify for the annual exclusion gift. The annual exclusion gift is the ability of every individual to be able to give $15,000 per year per individual to an unlimited number of individuals. Typically, it does not apply to gifts made in trust. However, with the use of Crummey powers, those gifts can now qualify for those Crummey powers. So let's talk about how we get there. Well, typically this is done in situations where there are life insurance policies owned inside of trusts, and the grantor of the trust, who is typically also the insured, has to make contributions to the trust to pay those premiums. So normally we would want those contributions to qualify for the annual exclusion gift so it doesn't utilize their unified credit, which is the amount an individual can give away during their lifetime or upon their death. So the way that is done, based on a case settled long ago called Crummey v. Commissioner, is that the beneficiaries of the trust can have a power each year to withdraw their pro rata share of the contribution to the trust. And so long as that contribution is below $15,000, it can turn that gift into a trust into a qualified gift of a present interest and qualify it for the annual exclusion. It is recommended and often required that proper documentation be done to record that option. The trust sets out the rules as to what kind of notice the beneficiary has to have and what the requirements are for them to exercise or, on the contrary, not exercise that power. In order for our clients to meet that criteria, we generally prepare a contribution letter, which is a document completed by the grantor of the trust documenting how much the deposit into the trust was, and a Crummey notice, which is a notice of right to withdraw to the beneficiary documenting what their option is to request out of the trust as their withdrawal. We typically sign their acknowledgement of the receipt of the notice, and once the required period lapses, that then becomes an asset of the trust, not subject to any further criteria regarding withdrawal. In certain cases, depending on the asset of the trust, that power may carry over, but that would be dealt with in subsequent years. So, as you can see, the requirement of completing that documentation is critical. We want to assist our clients in doing that. We have a special program called our GPS program dealing with irrevocable trust that will allow us to assist the trustees of irrevocable trust prepare and document these transactions, as well as assist with the payment of the premium. If you have an irrevocable trust out there, you need to make sure you're preparing these notices of withdrawal. And if you want our assistance in doing that, please feel free to contact us. Thank you.